Hello visionaries, welcome back to my channel. My name is Marisa Talbert. I am the founder and CEO of Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. So today this video is all about commercial leases. I've been working with a few of my clients who are dealing with issues with their commercial leases, and so I wanted to make this video to give you all the details and tips to consider before you sign or enter into a commercial lease. As a business owner, you should know that every part of your lease is negotiable and is usually going to be dependent on market conditions. With that in mind, you shouldn't be afraid to ask for what you want regarding the terms that are important to you as the tenant. Now, I should sound like a broken record when I say that your commercial lease should be read fully and completely line for line. If you don't want to read it, pay an attorney to read it for you, because those terms come back to bite you in the butt after you've spent thousands of dollars improving the property, but you didn't read that your landlord could terminate your lease with 30 days notice, and all the improvements that you made are now owned by the landlord. These things do happen because in most states, commercial leases do not get the same protections as residential leases, and that's for good reason. Another quick tip that I'll give you before we actually jump into the lease provisions is that as the tenant, you should be verifying that the landlord either owns the rental property or has the right to lease it to you. Generally, you can verify this through your Secretary of State or county record filings. Also note that in a commercial lease, the landlord will typically be called the lessor, the tenant will typically be known as the lessee, and the rental property will generally be referred to as the premises. So if you hear me use those terms throughout the video, you'll know exactly what I'm talking about, but for the sake of simplicity, I think we'll stick with landlord and tenant. Okay, so now that all of that's out the way, let's get into some of these lease provisions that you need to clearly understand and be aware of. All right, let's jump right into it. Number one is the type of lease. There are three general types of commercial leases. The first one is a gross lease. A gross lease is where the rent that is paid by the tenant is a gross payment to the landlord. And from that rent, the landlord has to then pay its operating costs, property taxes, insurance, maintenance fees, and then keeps what's left over. Another type of lease is the net lease. A net lease is where the tenant pays the landlord rent and also pays or reimburses the landlord for those operating expenses such as property taxes, insurance, and other maintenance fees and costs. As I mentioned, with the net lease, you're either paying one or more of these three categories of expenses. So either taxes, either insurance, or maintenance. If you're paying one of those three categories, then you have a single net lease. If you're paying 2 out of 3 of those categories, then you have a double net lease. And if you're paying all 3 of those categories, then you have what's called a triple net or a triple N lease. The last type of lease that I'll talk about is a modified gross lease. A modified gross lease is a hybrid where the tenant pays rent and also both the tenant and the landlord share some of those additional costs. An example of a modified gross lease might be where the tenant pays rent, the tenant also pays utilities, but then the landlord takes care of the property taxes and insurance. A modified gross lease is most common in a multi-tenant property, such as an office building. Obviously, a gross lease is more favorable to the tenant, and a net lease is more favorable to the landlord. And you should understand what type of lease you have, because a smart landlord is generally not going to spell it out for you which type of lease they're giving you. They're going to have the terms, and you need to understand what type of lease you have so that you can make the best informed decision for you and your business. All right, number 2, lease terms and renewal options. So the term of the lease refers to the duration of the lease. How long does the lease last? Is it 1 year long? Is it 3 years long? What's the term? Longer lease terms offer more stability, while shorter lease terms offer more flexibility and may give you a higher chance to renegotiate for more favorable conditions at the end of that lease term. Definitely so if market conditions change. Provisions dealing with the term of the lease should include the date that the tenant can take possession of the property, the date that the tenant must start to pay rent on the property, and the date that the tenant must return possession back to the landlord. Additionally, the lease should include information about whether the term may be renewed, and in most cases, a commercial lease is intended to be renewed at the end of the lease term. And if so, then you need to identify the deadline for when you as the tenant need to provide notice to your landlord in order to exercise that renewal option, or in order to inform and notify the landlord that you will not be renewing. You may need to inform your landlord maybe 30 to even 60 days or longer prior to the expiration of the lease term, and failure to provide that timely notice may either forfeit your option to renew or cause you to pay additional fees for a late notice. All right, number 3, let's talk about rent and additional costs. I think by now we all understand the term rent. We understand that you are paying money in exchange for the right to use a rental space. However, the lease must explain the amount of rent that is due each month, or the formula that is used to calculate the rent that will be paid each month. As we alluded to when we were talking about the types of leases, there are also categories of rent payments. Number 1 is a base rent, which is just a fixed monthly rent, $1,000 a month, $2,500 a month. That's considered a base rent. Number 2 is a base rent plus costs. This is typically determined based on whether you have a gross lease, a net lease, or a modified gross lease. Number 3 is a percentage rent, which is the landlord's right to receive a percentage of any profits or revenue generated during the term of your lease. Another common feature of a commercial lease, and really all leases, is a security deposit. A security deposit is used to protect the landlord in the event that you fail to pay rent or something is damaged at the time that you return possession back to the landlord. There may also be common areas maintenance or CAM expenses, and these are expenses for maintaining the common areas of the property. CAM expenses are usually calculated by dividing the square footage of the tenant's premises by the square footage of the entire building or project. It's important to understand how CAM charges are billed and what those expenses will cover. You will also need to be aware of rent escalations to understand how your rent may increase either during the lease term or upon each renewal of the lease term. Another rental escalation that most tenants don't realize or don't understand because they don't read their contracts is the holdover tenant rental increase. A holdover lease provision states something like, if your lease agreement ends July 31st, 2024, and you have not returned possession of the property back over to the landlord by July 31st, 2024, then your lease agreement becomes a month-to-month lease agreement, and your rent is increased by 150%. That means if your base rent was $1,500 a month, it now becomes $3,750 a month, as in $3,750 a month, because it's going to be your base rent plus a 150% to 200% increase. That is a holdover provision. Additionally, make sure that you pay attention to any penalty payments that could be incurred during the term of the lease, such as a late payment for paying rent late, or a return fee for if rent is unable to be paid due to insufficient funds. All right, number 4, property use and restrictions. Most commercial leases will state how the tenant may use the rental property and will specifically forbid any other unauthorized uses. This is important to note because if you want to expand your business operations during the lease term, it may be difficult to do so because you didn't negotiate this provision before signing the lease. If you as the tenant have a specific use that is important to you, then you need to make sure your lease contains that as a permissible use. Also, if you are in a multi-tenant complex, then you may want to insist on being the only tenant who provides the specific services or goods that you offer within that same complex. For example, if you are a deli, then you should insist on being the only deli in that multi-tenant complex. You should also be aware of any restrictions such as limitations on signage, business hours of operation, and alterations to the property. Speaking of alterations, let's talk about it. Number 5 is improvements and modifications. This lease will likely set forth the rights of the tenant and the landlord when it comes to making alterations and modifications to the rental property. In most cases, a tenant is not allowed to make alterations or modifications without the landlord's consent. But your lease should be very clear on what type of alterations can be made, whether structural or non-structural, the maximum amount of cost that may be invested by the tenant, whether the tenant or the landlord owns the improvements at the end of the lease term, and whether the landlord is obligated to pay any cost toward alterations that are involuntary or required by a change in the law, such as a ramp that has to be installed pursuant to the American Disabilities Act, or a new fire sprinkler system that must be brought up to code because of changes in commercial buildings. So you can see how these provisions can greatly impact your success in a rental property and how understanding these provisions are crucial. I mentioned the American Disabilities Act, which prompts me to talk about number 6, requesting an ADA disclosure from your landlord. In some states, such as California, the landlord is required to notify the tenant on whether the property has been inspected by a certified access specialist. If so, the landlord is required to provide the tenant with any report generated from that inspection. But no matter what state you live in, you should request this information, even if the landlord is not required to automatically give it to you. A certified access specialist is a professional that has been certified to adequately assess a property's compliance with state accessibility standards and the Federal Americans with Disabilities Act. As a tenant, you have every right to expect for your landlord to deliver the rental property over to you in full compliance with all accessibility standards. And your lease should address who will be liable for ongoing costs of ADA compliance moving forward. All right, so this video is getting a little bit longer than I expected, so I will make a part 2. But the last thing that I'll talk about for this video specifically is number 7, which is parking. You need to make sure that you have adequate parking for you, your employees, and the people who will patron your business. This is often overlooked, but it can be reasonably negotiated. If you are in a space where only street parking is available, then it's not reasonable for you to expect to have a reserved parking space for you. Likewise, if you're renting property where there are 10 parking spaces for 8 businesses, then it may not be reasonable for you to expect to have 3 reserved parking spaces for your business. But you should have at least 1, and you may be able to negotiate and pay for a second parking space if you need it. However, if you're renting a property that has a parking garage with 50 spaces for 10 different businesses, then it is very reasonable for you to expect to have 3 to 4 reserved parking spaces for you and your business employees and patrons. The bottom line is that you should not skip over parking, and your lease should clearly state what rights you have. Okay. As I said, I'm going to stop here. We'll pick up the rest in part 2. I hope this is helpful information. Let me know your feedback and questions in the comments. And don't forget to like, subscribe, and share with a friend. As always, this is Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. And I'll see you in the next video. I done made it this far.